240 calls, 66 pages of messages.
Saying I love her.
But there's a court order. Do you know what a court order means? Or are you above the law? And you will get 93 days on each and every phone call. Do you understand that? On the record in the matters of the state of Michigan versus Willie Lee Green, 25-01974, 25-02381, appearance two. Today was the date scheduled in both files for preliminary examination. There's an assault with intent to do great bodily harm, interfering with the crime of court, domestic violence third, and interference with electronic communication, and another DV third, and assault with a deadly weapon. My understanding is that the prosecution had a request or a special request.
Yes, Your Honor, the people will be requesting a jury today for a couple of reasons. First, kind of take this in chronological order as it happened to me. This was originally set for a preliminary examination back in October. I was in trial at that time. I had Cassie handle that for me. And based on those notes, there was an adjournment requested by the defense, 21 days.
He was also in trial.
I was in trouble with Mr. Fife.
Yep.
Oh, okay.
Okay. In preparing for today's examination, I discovered that the defendant had called the victim between that original hearing and today. Hold on, it changed because he called her 7 more times last night. 240 calls, 66 pages of messages, and more video visits than I had the time or will to count yesterday. I forwarded these over to Mr. Kaplan, and I said, this is what I have. My intention is to ask for a continuance to start with the officers, and then get a continuance to have the detective look at these, review them, make a more formal report, because just based on the e-messages, it's lots of manipulation. I love you so much. When I get out, I'm going to be able to take care of us and our baby. And I'm facing 7 life sentences, and this is so terrible. Things like that, that traditionally influence a victim to not testify and to remain on his side. And that was just from the e-messages, because those are far easier to scan through than calls and video visits. I also offered.
This is crazy.
Yep. I also offered.
You have to be a retard to be in jail and video visit with someone that the court ordered you in 2 files not to have contact with. And Mr. Willie Green, no Lee, is not a retard. Are you?
So I offered to waive the examinations up because Mr. Green is on dead time. So adjournments are not in his favor because he's on a parole hold. So I offered to waive these up today. So they're up to the circuit court faster, and work out a plea agreement where traditionally what I often include is I won't pursue witness interference charges before this date as part of the eventual agreement. And it's my understanding he wants to run the examination. So prepared to run it, wait for an officer to get here, had another officer call him.
Witness interference and bond violation.
Correct, Your Honor. P53s as well. Able to get a hold of the officer. To his credit, he was upfront with me that he forgot that he had court today. He didn't say he was sick. He didn't say there was an issue with the subpoena. I asked him point blank. He said, no, I'm pretty sure I got it, and I just screwed up. So my officer is not here because of that. So those are the 2 reasons I'm asking for an adjournment. But the other thing I want to make the court aware of is that this is not the first time Mr. Green has done this, because when I went to save these e-messages to my computer, it said I already had a file under that name. Because when I last had Mr. Green in 2023 for other felony domestic cases with the same victim, he did the exact same thing back then, where he was calling her and messaging her and using other inmate accounts over and over and over again. So
last time,
he knows he's not supposed to.
Sorry?
also, you said you go to count last time. Saying on record
I don't want you to say anything, because anything you say is on the record. That's exactly what I want you to say. I don't want you saying anything that's going to hurt the case right now.
So because of that, Your Honor, I'm asking for an adjournment in these matters, so that way a detective can listen to the jail calls, write up a report, and then proceed under likely forfeiture by wrongdoing, but then also adding witness interference charges, and I'm requesting a PA-53 hearing in each file.
Thank you. Mr. Kaplan.
Your Honor, I received these an email yesterday with some documentation from Mr. Pfeiffer. I have not had a chance to review any of it. just because I'm preparing for other trials right now. This case was originally scheduled for preliminary exam October 9th. As Mr. Piper said, we were in trial together. Mr. Freeman covered that hearing for me. My client did not waive his 21 days. Your Honor granted an adjournment at that time for good cause because
I didn't have a choice because
well, I
the
understand.
attorney didn't show up.
Now the prosecutor's asking for another adjournment for good cause because his officer's not here. As to the other information, that certainly can be charged if the prosecutor wants to charge that. We're asking for dismissal. My client, as mentioned, is on dead time. Prosecutor can always, refile with the new charges if he chooses to do that. So,
Got it. He's getting arraigned on bond violations in just a moment. So that's probably not going to work.
I haven't seen the
Just based on the prosecution's representations to the court, I have enough to advise your client that he is subject to bond violations, a bond violation proceedings, a contempt of court. And so you are, or have the right to have a hearing, a contested hearing as to the allegations that you violated your conditions of release and custody, which says you're not to have contact directly or indirectly with a Brittany Prokowski. And that you were advised of that on September 21st in both files. And so you're subject to the penalty for contempt of court for each violation. Do you understand that? It's up to 93 days in jail and up to $7,500 in fines. You understand that, sir?
We're now on the record in a Michigan district court, where what began as a routine preliminary hearing has shifted into something far more serious. The prosecutor has just laid out extensive evidence that the defendant repeatedly violated a no-contact order. Dozens of calls, messages, and video visits made from jail to the alleged victim. Those violations aren't procedural issues. They are potential acts of contempt of court, each one carrying its own criminal penalty. The judge has made it clear, these communications are not harmless, and they are not protected by intent or emotion. Once a no-contact order is issued, any communication, direct or indirect, becomes a separate legal violation. At this point, the court is no longer weighing guilt or innocence on the underlying charges. It is addressing compliance with court authority, and whether the defendant understands that court orders are not optional.
Are you trying to gather understanding, or are you just maintaining? No, actually, you understand that the contempt of court procedure. So I'm going to assume you're entering a plea of not guilty as to these violations. So the court will have these set out. As to the request for the underlying matter to be dismissed, that is going to be denied because in light of the additional, the new information, I don't know what's going on with the officer. I think if the officer had just blown it off and we didn't have such seriousness of cases, we're talking about domestic violence third in both files. We're talking about assault with deadly weapons, assault with intent to do great bodily harm, less than murder or by strangulation, and then interfering with the alleged victim's ability to make a crime report, to which your client is being charged with an habitual offender fourth offense notice. So this is a pattern of behavior that's being reflected here. And based on the representations of the prosecutor, the victim alleged in this matter, Ms. Brittany Prokowski, this is not the first time she's been a victim. She was also the victim in, I'm assuming, the conviction from 2023, or maybe another case that was charged in 2023. And then there's allegations of video calls and other communication while you're in the custody of the jail after being arraigned on this matter with this individual allegedly engaging in activity or communication that would manipulate and or cause her not to want to be a willing participant in the prosecution of this case? You have something you want to share?
Saying I love her is.
Your Honor,
You said you loved her. No, saying you love her doesn't. It's not manipulation. Saying you love her, though, is an admission that you had a communication with her that you weren't supposed to have.
Your Honor, I just want to say if my client chooses to speak, he's doing it against my.
You've advised him multiple times on this record, but he is like he's willing to admit to the violations. I recognize that you can't get Miss Brittany off your mind. I recognize that. You know how I recognize that? Because you got it tattooed on your head right now. But there's a court order. Do you know what a court order means? Or are you above the law? I think you think you're above the law. I think you can do what you want. Someone tells you you can't have contact, and you think that because I tell her I love her, that doesn't count. And to the contrary, I think the allegations are that you did more than just tell her that you love her. But you don't get to communicate with a person that the court told you can't communicate with because you have already allegedly assaulted her with intent to do great bodily harm, less than murder or by strangulation. In 2 separate files, you have a domestic violence third and another time where you allegedly assaulted her with a deadly weapon. You don't get to communicate with her to tell her you love her. You don't get to do that. Okay? Okay, and so I don't know. Unfortunately, English is my only language. I don't know any other languages I can communicate this to you in. But there's no contact between you and Miss Brittany. And to ensure that, I'm going to suspend all of your communication privileges while you're in the custody of the jail. You will only be able to communicate with Mr. Kaplan. You can fire whoever you want and hire an attorney yourself or represent yourself. That's your right. You don't get to get a different public defender. Did you recognize that?
Everybody else, I don't.
I don't know what you're talking about. You don't get to select which public defender you're going to get. Mr. Kaplan is already conflict counsel, correct?
No.
Oh,
there is no conflict counsel.
Oh, you hired him.
No, I'm public defender.
Oh, I didn't know you were at the public defender's office. Okay, very good. And so you don't get to select which public defender you get. No, that's not how it works. You don't get to decide that I don't want this one, I get another one. That's not how this works. There is an assignment that was made at the office of the public defender. They handle that. The court doesn't even get involved in that. And Mr. Kaplan was assigned to represent you in this matter. If you don't like his representation.
He's not representing. He just showed up to court. I don't got no police for. I don't even know what I'm in here for. I don't even know what I'm out.
You don't know what you're in here for. You've been arraigned.
I don't know nothing. I have no police report, nothing. I don't even know what's going on.
You're requesting to meet with him to go over the discovery. You can fire him, but then you have to hire your own attorney. That's not how the public defender's office works. You don't get to just swap out and you get another public defender.
I've seen multiple people fire their lawyers and get me.
Okay. Well, you can't. Any other questions about that?
I will make sure he gets discovery in jail. It may take some time, but we'll have a.
Well, it sounds like there's additional discovery coming in. Right. Your attorney and the prosecutor has already represented on this record that at your last court date, they were both in the same trial. So that's probably why you were not able to meet with your attorney to go over discovery. But you were busy allegedly making phone calls talking about your love. Anyways. Excuse me? Pardon? I can't hear you.
There's nobody in here. There's no police, no victims. Y'all keep postponing my court dates.
Who's y'all? Y'all keep postponing. I ain't y'all. That's number one. My name is Judge Simmons to you, or you can call me Your Honor. The other thing is the only reason why this case was postponed previously is because the attorneys were in trial.
That's only a week or 60 days.
Says who? You decided how long someone else's trial was going to go, and you decided how long I had on my docket or when I was going to be available. You decided that. Why don't you work on deciding how you're going to control your own actions first, Mr. I got Brittany tattooed on my mind. Okay, decide that you're going to be in compliance with court orders so that you don't get a contempt of court, because I guarantee you I will run it up in here. I will charge each one of them individually, and you will get 93 days on each and every phone call. Do you understand that? Your phone privileges are suspended, pending a hearing on the violations. Discovery will be turned over to your attorney. Your attorney will meet with you, so that you all can go over the discovery. If you fire him, you let us know who you're gonna hire. We will get you a new court date. It will be in 2026, obviously.
Thank you, Your Honor. Should I wait for the court then? or
We're gonna
you
give it to you right now.
Oh,
February 5th at 9:30.
February 5th at 9:30.
and that's for the bond violation and the preliminary.
That's correct.
All together.
9:30? Thank you, Your Honor.
This hearing wasn't about guilt or innocence. It was about control, compliance, and respect for the authority of the court. The prosecution established a pattern: repeated contact with the alleged victim, despite clear no-contact orders, echoing behavior from prior cases involving the same parties. That history mattered. The judge drew a firm legal line. Expressions of love do not override court orders. Emotional intent does not excuse prohibited conduct. And misunderstanding the law does not suspend its consequences. By suspending communication privileges and setting contempt proceedings, the court reinforced a fundamental principle. Protective orders exist to preserve the integrity of the justice process, not to be negotiated from a jail phone. This ruling underscores a hard truth defendants often learn too late. Once a court speaks, compliance is not optional, and defiance carries its own sentence.